This is the editing committee. I see a lot of new faces tonight, so I thought maybe I'd kind of explain what's going on here. This is an edit committee for the oil and gas regulations. Hopefully you're in the right place. Generally, if we don't have very many people, we're pretty informal and relaxed as far as comments and so forth. We do have a lot of new people here tonight, though, so we might want to hold off until the end for people to make comments and so forth. Otherwise, we won't make any headway. But we will stop at what, 8 and let people make comments. 8:30 maybe. Okay. My name is Carolyn Parkinson. I'm the staff person here. I'm just a lonely planner. These are all the committee members. They've been working on this since last April, so some pretty dedicated residents. And we worked on, I don't know how much explanation I should give. The county is sort of following a similar process to Arapahoe's, where we have regulations that cover mostly items that the COGCC does not cover, that they see as our venue. And then we have an MOU process. The MOU process can be done administratively and cuts a lot of time out of the process for the applicant. So it's sort of the carrot that the county is using. The MOU includes a lot of best management practices that are more strict than what COGCC requires. So it's sort of our way of trying to get agreement with the operators to employ better best management practices. And in exchange for that, we give them a little faster process, like 6 weeks as opposed to 6 months. So that's kind of, I don't usually do this, but I see a whole lot of new faces, so I don't know how much people actually know about what's going on. I wanted to give the committee kind of a rundown of what happened today and how it got started. I did that LGB training last week, and in the presentation, when they were talking about the comments page that the LGBs could use to make comments on the individual permits, they said something about picking the most important issue, or maybe a couple of most important issues, and putting them in as comments. Well, it was a training, so I didn't say nothing. I waited till the next day, and then I sent an email to Nancy Prince, who's going to be here tonight. She's our liaison in this area. And I said, so when we met with you way back when you guys went down to COGCC and spoke with them, our understanding was that we'd be able to attach our MOU to the permit and send that in, and that you would have our back. And she, I guess, was at that meeting, in fact. I said, and that's how we wrote it up in our regs, that we actually attached the MOU to the form. It doesn't sound like that's how you want us to do this. So the response I got back was that first email that you got. And hopefully everybody got a chance to read that, because I didn't print too many copies of that. And then I called her on the phone and I said, this is kind of backpedaling. This doesn't seem like what we originally agreed on. And then she sent me the second email, which is a little bit more lengthy. And basically, my interpretation, and granted, it's just an interpretation, we can ask Nancy for more detail when she gets here, but they do not want us to attach the MOU. In fact, if we do, they're not going to leaf through it and pull out the conditions. So I'm not sure that there's any benefit whatsoever to attaching the MOU. They will, however, let us put our comments in and have that are in reference to our MOU. The LGB can do that. There's a couple of issues with that. The first is that there's only 20
local government
designees.
Yes.
So there's a couple problems with that. The first is that we can only make comments for 20 days after submittal. So it occurred to me that we may have to include some language in our regulations that requires them to submit to us first. And one thought was that they can't submit to the state until I've accepted their formal application. And the idea to that is that at least then I will have gone through it and made sure everything's there. I won't necessarily make sure everything is appropriate, but I've made sure they've submitted everything they're supposed to. And hopefully we'll be able to identify the things we want to make comments on. So that was one way. I also heard rumblings that COGCC may do something like that. They may make a requirement that the applicant notify us X amount of days prior to submittal. So that's a possibility as well. So that's their preferred way of doing it. Then I called Diane Casas, who's the LGB for Arapahoe. And basically what she told me was they were having the same reaction that we have. That, hey, you know, I thought you guys were going to back us up and help us enforce this, since we're little rural communities without much resources, and we're told that that's not really, it's not really going to work the way we thought it was going to. And in fact, what Diane told me is that she has been making comments in the LGBT space since it's been available, which has been a few months, and not one of her comments has been incorporated into a permit. So I don't know what to say about this. What Arapahoe ended up doing this morning, their board decided that they were going to go ahead and attach, they call it Exhibit A, we call it Amendment A, basically the BMPs, to the permits anyway, and send them in that way. But here's what she told me. She said that, as a for instance, just as an example, they have within their MOU a provision that they have to have the berms inspected every week, and that they have to be inspected within 48 hours after precipitation events. And COGCC flat told them we can't enforce that.
It doesn't surprise me, because the MOU in my mind has been contract between us and an operator, so the state's never going to be involved in that, you know.
Well, normally that would be the case. Well, we were told in the meeting in which, and I think you know, John was there, and Mary was, I don't think he made that, but the rest of us were all there, you know, is that that they would enforce that to us. The director was sitting right there. In fact, it might have been the director that said it. And based on that representation, the whole structure of this thing was changed from regulations to you know, to being dealt with in regulations to being dealt with the way we have now, which is kind of bifurcated between regs and PDU. And it just sounds to me like what we're getting. I mean, I read the earlier email, and I've just seen this longer one that you got. I mean, it just sounds like a bunch of gobbledygook is what we're getting from the state.
Really? That surprises you? So
call me now.
Call you over that.
Call me.
I don't see where that changes what we're doing at all.
Well,
because if once again, in my simple mind, the MOU is a contract, an agreement between us and any operators out there, then it's up to us to enforce those, and our enforcement of those is a legal procedure of OSSI to get some kind of remedy if they're not doing what they said they would. So I would not see it would be nice to think the state would come in, but I don't think the state probably has the resources to start getting involved in individual county squabbles with the operators working there. And two, I think it's a political hot potato for the state, to be honest, that they don't want to get involved in backing up county government. They never have in the past. So I don't find that odd. So I would say we should continue on what we're doing, and you know, my complaints up to this point are more of a procedural problem, and the fact that we seem to be repeating ourselves, and we kind of lost focus on what exactly we wanted to streamline this down to be. Maybe this is a good time to readdress that.
Nancy, this is Nancy Prince. Remember you guys have met Nancy before, and you want to address?
Yeah, I was just kind of hoping to clarify a little bit for you all. I remember being at that meeting with you guys. I think that was probably the first few weeks of August, and it was when they originally just started the local government meetings. The director was new, and the man who's my supervisor, Bob Frick, the new hearings officer, was new. And none of us really had a chance to, I apologize, we were all new. And as we've gone through the last few months, we've really come to a better understanding of how it is that we work best with the local governments, like you all. And that is, or don't work or whatever. I'm from the government, I'm here to help. But I think some of the confusion came in, I think, because we didn't understand how best to incorporate the private agreements into our permits. Because anything that comes into our permits and that's put as a condition of approval or a best management practice, a COA or a BMP, those are actually enforceable under COGCC rules. And there's one of our rules is 305D that says that conditions of approval are limited to things that are technically practicable and economically feasible and have the weight of our rules. You know, they're not in conflict with our rules. So in other words, a comment that you all would make that was not something that we could enforce normally as part of our rules. Unless we had clear direction that the operator had agreed to do that, it would be difficult for us to put that on as a condition of approval. However, when the operator submits their permit application, they put on what they call BMPs, best management practices. They're offering what they're going to do. And if they have a BMP in there, we don't evaluate that BMP to see whether that's part of our rules or not. We don't care. The operator's offering that. And so that's what our recommendation was to Arapahoe County, what it was to the town of Erie. There are a couple other places where we've actually implemented this type of a thing. And so, you know, we recommended that that your MOU state that the operator will put those BMPs in place. And what that does practically is our field inspectors have got their laptop with them, and they have access to the permits on the laptop. And it brings up those BMPs so they can see what the operator said they're going to do on the berms, for example. You know, so our inspector wouldn't necessarily go out and inspect the berms on a weekly basis, but if he goes out there and sees that there's something wrong with them that's beyond what we would normally look at, and it's something that's in that BMP, then the operator would make note of it. So in other words, if we don't have a height, you know, I'm just making this stuff up, I don't know this part of it, but you know, if we didn't have a height requirement, and you all told if the operator's BMP was that it had to be 3 feet high, well, the inspector would see that and would say, oh, okay, that's not 3 feet high.
So now that he says it's not 3 feet high, what happens?
Then he would make that as a failed inspection.
Yeah, I'm confused.
Good, I've done my job.
I'm easy to get confused too. So when we were up with Dave Esslin, he made it clear that the MOU was a contract between us and the operator.
Exactly.
And that if we incorporated that in a permit, the state would simply acknowledge it and enforce it. And you said the same thing. You've really said that if it's in the MOU, the COG would enforce it.
If it comes through the BMPs from the operator or it's approved as a contract.
Oh, okay, so let me understand what you just said vaguely again.
Yeah.
If it's a contract and the operator signs it and our MOU says he is obligated to conform to all the agreements he signed up for, is that MOU enforceable by the COGCC under your permitting process?
Not as a separate legal document. That, as you said, yeah. That, as you said, that's a private agreement and that's enforceable through whatever contract mechanism. But the pieces of it that are incorporated into our permit
you would expect to and you would enforce it. Here's my last question. Let's suppose the operator says that our MOU violates the state's preemption according to your rules, even though he has signed that document. Which enforcement takes place, ours or yours?
Okay, that is a good question, and I think the answer to that would be, and I'm not an attorney and my boss is, and he would yell at me if I said this, but my understanding of the law is that you've got this binding contract, you've got this MOU, and it's up to you to enforce the pieces of that contract. Our contract with the operator is the permit. And so the way to make the two contracts coincide is for the operator, your contract to say the operator has to agree with us to do what he's already agreed to you to do. And if he signs this MOU with something that he later on doesn't like, you know, then you guys have got a negotiation problem, or you've got a lawsuit problem, or something else.
Well, wait a second, because I heard you saying something different. I may have misunderstood you.
Okay.
I thought I heard you saying is if we signed an agreement with an operator, and I suppose we could have a requirement that says to get a permit from us, they've got to come to us first before they put their paperwork in review. And I'm not sure what you call the various pieces of papers that you get. What I heard you saying is if provisions from the MOU are incorporated into their, I guess it would be a permit application, as BMPs, you would enforce those
Whether they're in conflict.
whether they're stricter or in conflict
Right.
with your regulations or not. And you gave the example of the burn. And I guess the other option you mentioned in your memo is this comment process, but that seems to be puts us in some jeopardy because you're under no obligation to accept our comments and incorporate them.
Exactly.
And probably would not if they're in conflict.
Let me ask you a question also.
Yeah.
According to what you just said, Nancy, if under best management practices, it was in the record of the MOU, which you guys knew about, and so that would, he's talking about your inspector being on, installed the berm was not up to what had been basically privately agreed on, then is there any enforcement action, or do you just say, well, call up somebody here and say, yeah, this is what we found, and that's it?
No, what usually happens...
So all
yeah.
you're doing is acting as an inspector and saying,
Yeah,
and the reason I bring that up is it brings to mind in my head at least an interesting question. Because it seems the state has shown that they have no problem with suing municipalities that decide they don't want to allow fracking in their city limits.
I just came from Colorado Springs.
You just close your eyes and you didn't want that to come up to them. But the state will go to bat for the industry's rights to frack. And I think it's different between a county, at least in what you're looking at, and a high-density city where it's all house, business. But that's beside the point. So they have no problem with suing the citizens, basically, for not following state guidelines with the companies, but they will not back us up. Is that what you're actually saying?
Well, I guess I didn't finish my sentence.
Okay, then please do.
Yeah, because when you get a failed inspection, the way that our inspectors work with that is the first step is to talk to the operator and say, you didn't do what you said you were going to do. I'll be back out in a week or a month or whatever, depending on what the situation is, and I'll check and make sure that you did it. At the same time, if you have a good working relationship with the inspector and you ask the inspector to also notify you, most of the guys are pretty good about staying in touch with the LGDs, or even have them talk to me, and I can be in touch with them. If the incident still isn't taken care of, or if it's a serious, it depends on what it is. I mean, I don't know what the inspectors consider or what you all consider serious, but an NOAV can be issued, and that's a notice of alleged violation. And in the NOAV, they have, the way that it's written is they'll say, okay, we give you 1 month to take care of this. And you have to tell us not only what you're going to do to take care of it, but why it happened and what you're going to do to prevent it from happening in the future. Those are the 3 pieces of a notice of alleged violation. And depending on the situation, that can indeed go further to enforcement through the commission. So it's kind of a stepwise process, and there again it depends on the nature of the violation. If it's just that they need to raise their burn, that's to me is a little bit different than
I have a question for you regarding attaching the BMP. At what point in the permit process, COGCC permit process, can submit